Hello, this is Matt on the Moon Family Sedan channel. Attorney John Deaton shares some things about a court document which he does have that he cannot release due to local court rules. And he says that this document is pure fire, and that's a quote. The document that he will be able to share it at some point in the future, it seems. He says it's pure fire. And also, Attorney Deaton says that, the judge in the library case is keenly aware, which is also, quote, keenly aware, of the issues surrounding secondary market sales, and notes that an upcoming hearing is of crucial importance. And so I want to share with you some of the more recent comments. This is from just a couple days ago from Attorney John Deaton. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And before jumping in, I will note that part of what Attorney Deaton cites here in this thread has to do with library and Naomi Brockwell, who is represented in the amicus brief that Attorney Deaton filed in the library case after library actually lost, because we're in the remedy phase here. But the amicus brief was filed on behalf of Naomi Brockwell, who is a content creator who has a LBC, the library credit token, but she's never bought it and she's never sold it. But she has a bunch of it. And so there is no clarity for her in terms of what she's allowed to do, not do with it. And Attorney Deaton is seeking to have such clarity. And this judge, though, he may be a really smart dude, but what's troubled me in part is that this judge in the library case doesn't seem to be willing to rock the boat whatsoever. It seems more like, to some degree, he just was thrown into this. He's in over his head. He doesn't know what to do because it's pretty damn clear that the existing regulatory framework out there regarding Howey and how it's historically been applied, you can't shoehorn crypto into that, because you get all of these interesting questions that pop up that are unique to decentralized cryptocurrencies, and part of it having to do with utility. Does that change anything? And the judge in the case certainly seems to recognize that utility is something that, it's certainly a real thing in the library case here. The LBC token clearly has utility, and he even brought it up throughout the lawsuit. But still, he's been kicking the can down the road. He sure has to this point, in terms of having some sort of discussion and some sort of finality regarding what that means on secondary markets where people buy and sell LBC outside of the library organization. So Attorney Deaton says the following. On January 30th at 3 p.m., there's a hearing in the library case. I've been admitted in the case and filed an appearance on behalf of Naomi Brockwell. It is my honor to represent Naomi, who epitomizes the need for regulatory clarity regarding users and secondary market transactions. Naomi has never purchased a single LBC and has never sold LBC. She earned the LBC she owns through user tips, purchases by viewers, and user rewards. Naomi has never cashed out any of her LBC because it is far more valuable to her to keep the LBC attached to her channel, because staking helps her videos get viewed by a larger number of people. Again, to this day, Naomi Brockwell has never purchased or sold a single LBC. Naomi uses the library platform every single day. As a content creator, it is a great place for her to build an audience and feel comfortable that her channel is not going to be taken away from her. Isn't that one of the beauties of a decentralized platform and why we need an alternative to YouTube? During the last 5 years, Naomi has accumulated all of the LBC tokens that she owns by utilizing her channel. Naomi wasn't even aware that the LBC tokens that she had accumulated through her channel had a monetary value associated with them until only a few years ago. Again, she has never sold or bought any LBC tokens. She uses the tokens on a daily basis in the ordinary course of her business to post content, to give her content more visibility, and to access certain videos. On November 7th, 2022, the judge in Library entered an order granting the SEC summary judgment. The court's order does not reference secondary market acquisitions of LBC, nor does it address LBC token holders like Naomi, who acquired LBC for non-investment purposes. The court did conclude, however, that many individuals like Naomi acquired LBC for consumptive use only. At the July 20th, 2022 hearing, Judge Barbadoro said, quote, "I think this record does contain evidence that there are consumptive uses for LBC. I think that's undeniable," end quote. Yeah, so folks, I know that the judge recognizes this. I've talked about it on the channel. I was talking about it last summer too. But still, there isn't clarity for participants in the space. It still does not exist. Isn't that troublesome? Shouldn't that problem be fixed? Well, obviously, yes. Attorney Deaton then says, in my amicus brief, I cite at NY Crypto Lawyer, so this is Lewis Cohen, Cohen's since incredibly important article, The Ineluctable Modality of Securities Law, while fungible crypto assets are not securities, dated November 10th, 2022, and I attached the entire article as Exhibit B to my amicus brief. And so, folks, you may recall that that document. It basically went through all of the case law surrounding like the Howey test, everything, and just spoon-fed it, did a full analysis on it, and just spoon-fed it to the judge, which was an incredible amount of work. But I love that happened. It's a gigantic document. I can't remember how many pages. It's like, I think it's over 100 pages. Gigantic, though. It might have been closer to 200 pages. I can't remember. But just spoon-fed that to the judge is like, yeah, here you go. So what the SEC is claiming is outside the parameters of what we have seen actually unfold if you look at all existing case law. So, like, that's why if the SEC wins here, then the SEC's novel theory, this would be an outlier. The novel theory would have won because that's what the SEC effectively has. Anyway, Attorney Deaton continues. I cite Lewis's article for the judge's order failed to distinguish among the sales that were made to purchasers that had a bona fide consumptive intent and those who were offered and who purchased LBC tokens with a reasonable expectation of profit from the efforts of Library. There was a court hearing on November 21st, 2022. I have the court transcript. This is what I was talking about at the outset of the video. I have the court transcript, and I can tell you that the transcript is pure fire and that Judge Barbadoro is keenly aware of the issue. The fact that he granted a hearing and allowed the amicus brief is proof positive. Due to local rules, I cannot publish the transcript on crypto law for some time. The purpose of the November 21st hearing was to discuss the appropriate remedies sought by the SEC. Jeremy Kauffman, of course, the founder of Library, Jeremy Kauffman spoke up and offered to divest Library's all remaining pre-mined LBC tokens. Doing this would mean that no secondary token holders could be argued to have a reasonable expectation of profit based on the entrepreneurial or managerial efforts of Library. At the November 21st, 2022 hearing, the word clarity in regulation to secondary market transactions appears a dozen times. The judge recognized the need for clarity and urged the SEC to work with Library to resolve the issues, including by providing clarity to secondary LBC holders. According to Library, it provided the SEC with a settlement proposal consistent with the framework laid out by the court. After the parties were unable to reach a resolution consistent with the judge's suggestion, including clarity regarding secondary market sales, Library filed a motion to limit the SEC's remedies. The SEC has responded, and it will not offer any clarity regarding secondary market transactions. And folks, this is very telling. Think about this, and you'll see why I'm saying that as we go through a little bit further here. If the token itself is not the security, if the SEC doesn't think the token itself is a security, why not provide the clarity? Or as John Deaton ends up stating, like a no-action letter or something like that. Well, it's because their approach effectively is that the asset itself is a security. That's certainly how they're treating this anyway. And then Attorney Deaton says, the SEC attorney said in so many words that that's not what the SEC does. Instead, the SEC is seeking a permanent injunction, and you can read it for yourself. Clearly, Naomi, as well as hundreds of thousands of other users, have significant interests as secondary market token holders. People who have not transacted with or purchased LBC from Library or its executives, and who do not view LBC as an investment. I argued to the court that, today, LBC holders, like Naomi, arguably have a greater interest than Library. I point out that the judge recognized that Library could go out of business today, and the Library blockchain would continue in perpetuity, just like the Bitcoin blockchain. Yeah, and so, folks, that's another thing where I'm just like, you apply that to any coin, XRP or otherwise. How the hell can there be a common enterprise if without an organization, like a company existing, specifically Ripple here, they can go away, and then the blockchain continues to persist? And so, like, this is understood by the judges in these cases, but it's kind of like, well, they just don't know what the hell to do, it seems. And then Attorney Deaton says, Library has indicated that it will be dissolving the corporate entity. Thus, there are many holders, like Naomi, who want to use LBC on the Library blockchain and should be able to do so without confusion over whether secondary sales are restricted. If you could read the transcript, you would understand why this hearing is so important. The overbroad injunction proposed by the SEC alone speaks for itself. There are over 1 million users of the Library blockchain daily. 1 million, folks. I met Scaramucci's, I'm sure you've probably heard that name if you've been in crypto for a while, Anthony Scaramucci, American entrepreneur, founder of Skybridge Capital. Very wealthy individual, happens to not like XRP, but hey, is what it is. People don't have to like the same crypto as me. Heavy into crypto here. And so Attorney Deaton says, I met Anthony Scaramucci's professional crypto trader at a function that I was speaking at. His card is in my office. I brought up LBC to this professional crypto trader, and he responded, I've never heard of it. Ask yourself, how many people are truly speculating on LBC's price? Plus, the SEC has stipulated that many, if not the majority of LBC holders, are users and have no investment intent. The SEC couldn't prove the first prong of Howey, let alone the prongs related to these transactions. But it refuses to issue a no-action letter or give clarity. I don't know what the judge will do, but I know that this January 30th hearing is a very important hearing. Yeah, so I'm looking forward to seeing how things unfold as well. But this is the next, like, in terms of what's happening from a regulatory perspective in crypto, just on the whole in general, this is the next thing that is absolutely gigantic. And I'll be tracking it here. I don't know if we should be optimistic that this judge in the Library case is gonna do anything that's going to help all the people out here who are confused. And the fact that we're even talking about this should be proof that we don't have the clarity that the SEC insists exists. Like, the judge has to see this. Couldn't be more obvious. Really grinds my gears, folks. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.